Vice Prime Minister of Ukraine, Minister for the Reintegration of Temporarily Occupied Territories of Ukraine, and Oleksandr Bakumov, People's Deputy of Ukraine, Chairman of the Interim Special Commission for the Verkhovna Rada of Ukraine on international humanitarian and international criminal law in the conditions of armed aggression of Russian Federation against Ukraine. Good evening, everybody. Thank you, dear colleagues. Thanks for coming to discuss the issue of international humanitarian law, since the fact is the circumstances and the history awarded us the attempt to feel what international humanitarian law is in action, in effect. So as a person who was taking care of the humanitarian corridors for organization of humanitarian headquarters on exchange of prisoners of war, kidnapped and lost children, and mechanisms which were supposed to work, we've witnessed that mechanism did not work. We have to recognize it, and it's our destiny to become the platform for the world. And I think the draft law is one of fundamentals. I think that it will become a law soon. I want to thank Oleksandr Bakumov, who headed the process, and there was a commission created in the parliamentary platform. There was a number of meetings held. We involved a number of organizations, community organizations, charity organizations, everybody and all, so that one of first draft law was born. We are presenting it today. I want to thank Mr. Oleksandr. He's the expert in this field. He knows for sure what has to be done in legal field, and us politically, as the Cabinet of Ministers, as the President's team, we know for sure how important it is for the world. And in some time, it's not hollow words. We will create the agenda for the new humanitarian law, new world order. And unfortunately, or maybe fortunately for the world, we will do it pretty well, because unfortunately we know on our experience what it is when the mechanism does not work, when ICRC cannot, they are forceless, they can only observe, forcelessly observe, as it happened with the humanitarian corridors, like it happened in case of Azovstal. It was all lack of force, lack of strength, and feeling of impunity by Russia, and forcelessness on the standpoint of international humanitarian law, and absolute impunity demonstrated by Russia, and which they continue to demonstrate in our land. So I want to thank everybody who was working on it. The work was going on for weeks, for a number of weeks, and I hope that after the presentation there will be questions and we will find answers to it. I want to thank the Parliament and once again to Mr. Oleksandr for this titanic work which was done. Mr. Oleksandr, please. Thank you, dear colleagues, dear guests. Really, the issue of international humanitarian law is very important for our country and for the world as well. I'm saying the words of gratitude to Ms. Iryna, to the Ministry of Reintegration, who laid the fundamentals for this process, together with the People's Deputies, with our team. We were able to work out the draft law, which does not update the existing law, but which is another infrastructure draft law. What we're talking about here, I want to support Ms. Iryna's words. And yes, really, in Ukraine there is a period, awful period, when we have to look at the standards of international humanitarian law, and all the countries during the peacetime, they don't know what humanitarian law is. International humanitarian law is the law of armed conflicts, which was worked out during centuries of human history, and the last century it proceeded to approval of international conventions, a number of Hague and Geneva conventions which regulate the standards and rules of war, the standards of behavior with the prisoners of war, the rules of behavior in regard to civil population during armed conflicts, and the infringement of these standards are the war crimes, something that we're talking about on a daily basis, that every criminal, every combatant of Russian Federation who committed a war crime in Ukraine, first of all, is the infringement of rules of war. They all should be punished. The not only national law mechanisms, but international legislative mechanisms should be applied to them, which would result in their punishment. And this draft law on the application of humanitarian law in Ukraine opens for us as a nation the opportunities to understand how the standards of international law are being implemented in Ukraine. What are the sources of international humanitarian law? Because there's a multitude of questions, like by what international agreements Ukraine is bound with, because the Geneva Conventions date back to 1949, and Hague Conventions even earlier, and we not always have the connection with them because there are notes which date back to Soviet Union and other documents that we consider ourselves bound with, but there are no real legal grounds which would indicate the full compliance. But us as a state which govern ourselves with the rule of law, with the help of this law, we consider ourselves bound by international humanitarian law and conventions worked out during the last centuries and decades in Europe. We will have something to talk about today, and I will pass the mic to Ms. Iryna for presentation of the draft law. Let's see the first slide. First of all, yes, we are saying that yes, what this legislation is adopted for. We focus our attention on the fact of in implementation of the standards of international humanitarian law. It's been implemented during the complicated period of conflict between Ukraine and Russia Federation. So the fundamentals of international humanitarian law are Hague and Geneva Conventions, and we have, and now that we acquired our sovereignty, well, not our sovereignty, but the Act of Proclamation of Independence dates back to 1991. We don't detailize specific acts like Geneva or Hague Convention, but international humanitarian law is already formed, and the experts and the specialists, they understand these sources. We use the regular international humanitarian law, the authorized commissions of the Parliament in implementation of regular international humanitarian law, since the world complies with the rules of war and comply with the notion that these rules cannot be infringed because it's a war crime, and some positions, they are not prescribed by international law. It's just a tradition which is formed during centuries within the years of conflicts, and the explanation in the standards of humanitarian law, whether it's just a tradition or it's a law, so the Commission can give the full explanation of these notions. The Commission made up of specialists and experts which are reputed in the field of international humanitarian law. We can strictly specify who and how provides the implementation of standards of international humanitarian law during armed conflicts. May I ask for the next status? The detailization of the status of National Information Bureau. In compliance with our international obligations, we have to have the National Information Bureau, which currently acts thanks to our ministry, but we detailize it and we provide it with the status on the national level. It describes the duties and obligations and responsibilities. For example, in cooperation with ICRC, the Commissioner for International Humanitarian Law. We established the Office of Commissioner for International Humanitarian Law, which would unite all the functions related to application of international humanitarian law. There are some questions to discuss regarding the Commissioner, for example, for Commissioner for Human Rights. Is there whether there will be competition? But we don't foresee any competition here, because the Commissioner for Human Rights, their office is the office of parliamentary control. And now, during the armed conflict, the responsibilities increase multifold. It's the issues of prisoners of war. It's the civil population during occupation, the bodies of the perished ones. And this war in the legislative branch of the government should be headed by a person who is professionally prepared, qualified, and who is ready to take these responsibilities. So we foresee the office of the Commissioner for International Humanitarian Law. And let's be realistic, the international humanitarian law in action will not end after the Truce Treaty, which will renew our borders as of 1991, when we will get the reparations. And if the treaty will be in effect, we will keep searching for body. We will be searching for the missing in action. So there is a huge pool of work to be done, and I don't think that the work of the Commissioner will end after the end of the armed conflict. It's very important, and in the view of the fact that Ukraine has a lot of forces, of defense forces, the security forces, they should be always prepared. They should know what international humanitarian law is. The draft law also specifies the provisions for training in international humanitarian law, because every person who takes up the arms, who becomes a combatant, they should be familiar with the rules of war. That's very important, because we get integrated into European Union. We confess in humanity, in humane society. We have to understand that our servicemen know how to do the war in the right way, because it's war is a right to kill, but it's a right to kill a combatant by another combatant. One serviceman kills another, and this is what's offered in this draft law. Constant parliamentary control during the conflict. I would say it's a parliamentary procedures of support for the executive branch of the government, special commission acting during the time of the conflict, which would provide the compliance, which would ensure the compliance with the standards of international humanitarian law. We offer such commission, such temporary commission to work in the parliament during the conflict, which could always be gathered and work over the issues related to international humanitarian law. And that commission should consider the issues of compliance with the people's rights and freedoms in the occupied territories, the issues of prisoners of war, returning of the prisoners of war, and it's a complicated integration in the international humanitarian law. For example, there is a part of the work of the committee on the law enforcement agencies' activities. I'll give you an example. When the committees of the parliament supported the amendments of the law to the criminal law, for example, the persons who are prisoners of war, who are behind the bars, when Russian Federation says that give them back to us and we'll give your prisoners back, because we give them not their combatant who should potentially be convicted. We will convict them ad hoc. We gather all the information before the exchange of prisoners. So we give them back to Russian Federation, and they give give us our prisoners of war who are actually heroes, so we had to update that law. And for such procedures, we need this specific special commission, which would be active during the armed conflict. Do we have any more slides? No more slides. Well, if there are any more questions to detailize, we are ready to talk over them. Dear colleagues, first of all, it's probably interesting during the development of this draft law. Did you study any international experience? Or was it used, or do we understand that world does not have experience like this and it was worked out by us? Yes, we obviously adopted some foreign experience, but we all have to state that under conditions like these, during this horrific period of history, Ukraine ended up in circumstances like this. No one had any practical examples within the last couple of decades. There were no classic examples which could be compared to the situations Ukraine ended up in today. And specifically, these conditions are something that give us the opportunity to work out this draft law. This is a unique draft law which says that Ukraine shows how exactly it will implement it. Other countries only use the international treaties, and we say that we are not only bound by international humanitarian law, but we lay the fundamentals as for our national law, which regulates the procedure of its implementation. I would like to support Ms. Iryna's rhetorics that in Ukraine now we're forming a new scientific study, new scholarship of the practice of implementation of international humanitarian law. We will witness the additional protocols. We will witness the Kyiv protocols to international conventions which will standardize the procedures of prisoners exchange, the exchange of prisoners of war, because such practical cases that we witnessed in our country is a bold infringement, brazen infringement of rules of war, with the use of new weapons, with the new technical capabilities. They force us, they bring us to the conclusions, they have us say to the international community that the procedures work out by now doesn't stand the challenges put in front of us today. For example, in case of efficiency of operation of ICRC, of their legal status in international law, because for what we know, it's not an intergovernment organization, like, for example, for founding members to sit at the table and say, go on, help liberate the civil population, monitor the compliance with the humanity rules, and the world cannot do it as well. And this is why, based on every such case, we have to propose the new mechanisms, the new models, and I'm sure these mechanisms will emerge. And there are many initiatives from the president's office, so from the parliament, for example, for the establishment of the specialized tribunal for war crimes, for aggression crimes. And we're saying that we all have to comply with the rules of war and also with the right of war, right to war. There is a specific algorithm to start the war. There was which were not complied with. There was no warning on the strikes. There were no ultimatums, and all these should be punished. For the war criminals to be convicted and punished, we propose to establish the specialized tribunal for crimes of aggression, because if not for it, this would not have happened, and the this draft law sheds light on this subject. What is the status of this draft when it is supposed to be submitted for consideration? We prepared it together with the Ministry of Reintegration. We worked through it, having engaged multitude of experts, and now we're in discussion with the relevant committees, with the people's deputies. I think that within a couple of days it will be registered as a draft law, and we're having understanding with the initiators and founders of this process that in this database it will be submitted as the draft law. They're offered to be signed by the people's deputies and by the commission. We think that it's a normal procedure for cooperation when deputies and the ministries and other parties involved, they share the responsibility, and the first right to sign will be given to the people's deputies. I think it will be happening shortly and promptly. And this is an example for international community. I want to give you an example. When all of us and ICRC, before the 24th of February, I was convinced that we have algorithm of action, we have a humanitarian reaction plan, we have mechanisms. And how big was my disappointment and surprise when I'm asking ICRC, you have an international mandate for mediation, and they're saying because it's impossible in order for the mandate to work, both parties have to give their consent to it if there is a war. And when we witness all possible infringements of the conventions, of all the international laws, for example, what is the mechanism to bring them to liability? I mean, for the party who does not let open the humanitarian corridor, even though there is a procedure and we do everything in compliance with the procedure, and they say there is no such mechanism, and we have to silently observe what's going on when we think that international humanitarian law, ICRC, United Nations, everybody just watches children, civilians, women being killed when the humanitarian corridor is refused, and even when it is opened, it's only by the agreement between the party, and the international institution only plays a monitoring role. And when we started getting deeper into the process, we understood that it only works in case of agreement between the parties. But if there is an agreement between the parties, so we don't need a third party. What kind of mandate is that? Just to stand aside and watch the things happen? Well, and it's not one single case. So inability to bring the criminal to liability, their impunity of the aggressor is what stimulates them, and what keeps stimulating them act in the way they do. We still have occupied territories. They don't let any humanitarian corridors in those areas. It's not being brought to the public space, but this is something we demand on a daily basis. So, and if taking it as an example, this will be the first legislation, the infrastructure legislation, to understand who does what on the national level, and the main thing that our international partners support us in that. And they say that you have a full right to be leaders in that, and indeed we will witness the emergence of Kyiv protocols, Kyiv conventions, and we will be the leaders in order to make sure that something that's happening now here will not repeat itself anywhere else in the world ever. Dear colleagues, if you have any questions, please take the mic, introduce yourself. Marina Kožuhar, Ukrinform. I have a question to Ms. Iryna. Did Ukrainians leave the applications for the psychological help provided in the hub? And what are the main reasons for such applications, and what are the most widespread cases? The head of our national bureau, Oleksandr Smirnov, went out for the exchange of prisoners of war. We have another good news. 50 prisoners of war were returned to us, and we're responsible for the follow-up of this process. Well, Oleksandr would have responded to your question in a more competent manner, but yes, we have applications like those you mentioned, and we thank the First Lady who took the responsibility for this issue of psychological help, and we take our experience from Israel when they provide us, they tell us about the experience on how to work with those who suffered tortures and occupation and isolation in occupied territories, those who were prisoners of war. They have many things worked out in that field. So this process is moving. First, the people were communicating with our employees with distrust. Only 3% of those who call to the hotline, they recognize that they need psychological help. And only during the conversation, the people who were providing other information, consultation, they detected that yes, such help is necessary. And during dialogue, they were understanding that such help is needed. We have no culture to recognize it and only resort to psychological help. It always comes in a complex. For example, in case when the people go missing, they look for their missing relatives, or they don't want to recognize the results of the DNA test. So it's a complicated process. And yes, if there are any prospects, we are ready to adopt it. We're looking for new ways, and because we understand this is something to come, something we will have to do in future. Any more questions? Well, Mr. Oleksandr, maybe the skeptics will say that we were always complying with international humanitarian law, always complying with all the conventions in effect, but unfortunately our enemy is not somebody who complies with them, and many people doubt that this law will change the situation dramatically. So how will it help us? How will it help us to force the other party to comply with the international humanitarian law, or will it only help us to align our internal processes? Well, it will help us arrange and align the processes inside our country. We cannot force the aggressor with no legislation to have them submit and comply with the international legislation. But when Ukrainian president, Ukrainian parliament positioned themselves as the state which has national legislation, which is efficient, which stipulates that for them international humanitarian law, its principles and rules are dogmas, and we comply with them, we guarantee all their rights for the prisoners of war. We know how our servicemen receive the knowledge on the international humanitarian law. We know that all of our servicemen, whom all the world considers as combatants, who enter into combat, they know how to act correctly in the combat in order not to infringe the standards of international humanitarian law. It makes us stronger. If it makes us stronger, the countries with the stable legislative systems like Netherlands, France, Italy, Germany, for example, the Hague, the capital of justice, they look at it and they make their conclusion how the country complies with the laws on the national level. And when we have this powerful instrument in our hands, which sets the framework for us, they make their conclusions and they understand where people really adhere to the principles and rules of war and where they are being brazenly infringed. Based on my experience, I support completely Mr. Oleksandr. We are talking about the internal regulations, but it will make an impression when we every evening where humanitarian corridors were not yet opened, we refer to every infringement made by Russia. We stated it directly. We documented it, that you did not open the corridor, no matter the previous agreements, and the ceasefire agreement stopped operating, we were sending letters to ICRC and to Russia on a daily basis. In a couple of days, the situation was changing. They were seeing that we go by the way of conventions. We warn them, we document any infringement, and this systematic approach, it put them, at least to some extent, into the framework, and to the extent possible, at least formally, they were trying to adhere to the international laws. And I agree, people are looking at us, and we want to remain the civilized state, no matter how horrific are the things happening around us. Let me add a couple of things. We had travel to Hague recently. We visited International Criminal Court, and there we had a discussion with the local court with the head of Supreme Court of the Netherlands and county courts, and we were discussing the issues with the judges of the specialized courts. And when we were talking, I was emphasizing this issue of development of the national draft law, which we want to implement, and we wanted to start to bring it into effect. And when we focused our attention on the issue of creation of specialized tribunal for crimes of aggression, it immediately resulted in their interest, and they evaluated this process very high. If a couple of months ago these discussions regarding the specialized tribunal, they were not so rapid, they were not so vivid, they were saying it's an only political resolution, political decision, the level of discussion now is quite different. They understand that to re-establish the justice, and no punishment can be possible without re-establishing the justice. It's impossible without establishing of such tribunal. I'm saying that all these processes are interconnected. International humanitarian law, laws of aggression, and war crimes. And when in discussions with the lawyers and with those who exercises the law, exercises the justice, when we discussed it with them, the evaluation was very high. Did anybody of our international partners got involved in the process of development? We were in consultations with the experts of Council of Europe who were monitoring the whole process of preparation of the draft law, and I am very grateful to them for their proposals. I'm thankful to the ambassadors of G7 for their reaction, and we received their positive comments. They understand that this law is for internal consumption, so to say, but we rely on the support of our international partners. And I only wanted to end to what Mr. Oleksandr said. You've heard the conviction of Girkin recently for this case of Boeing, which was downed in the skies of Ukraine, where Russia used the book SAN, but the way it was done, it took years, but the way it was done, it says that they feel now, and that there is a chance, that the big chance that they will be brought to liability. The word Hague sounds more and more frequently. I mean, our guys in the battlefield will do what they have to do, and it's obvious we will be winning. But now we have to win on a legal battlefield, and they all have to be brought to liability. The propagandists, the politicians, everybody who got involved in this catastrophe. And this law will be a good support for us. Dear colleagues, maybe you have any questions or comments, please get involved. Thank you. We have no questions in the studio. It's something new. Yeah, well, I think that people need some time to ponder over this legislation. So thank you for presentation of this draft law. I think it will be another stepping stone for building our democracy and to bring everybody to liability, everybody who should be. Thank you, dear friends. Trust in our armed forces, work for our victory, and